Hi, Brian again for our next video. This one is on client management. Now, obviously, the process of what we do is about taking that client through the entirety of their case. Now, that's a really important piece of what we do, and obviously, there's going to be a lot of differences between the different cases and the different kinds of cases that we deal with. I want to, at least in this video, kind of take you through what I believe a process would look like, and it needs to be repetitive. Client after client needs to be treated the same way. If we do that, it shows this quality standard of care that will take each one of our clients through that, and hopefully allow clients to be able to trust our firm, to refer friends and other people at the end of their case. Now, starting when we have a new client, and at this point, taking the assumption that they've already signed a fee contract, we've now gotten the retain, the go from accounting, say that that case is now ready to move. The first thing that we want to do in every one of our cases is to draft an opinion letter. Now, the opinion letter is the cornerstone of everything that you're going to do in the case. What I'd like you to do, and there's a standard opinion letters, you'll see it in different areas of practices in our World Docs forms. I want you to first take with each one of the cases the facts of the case. And you may take that from your notes. You may, as a paralegal, call the client up and take all of the salient facts in the case and draft them out. Now, I like to put in these facts a breakdown of the case in third person. So you're not saying you did this or you did that. Basically, in third person, that Mr. White, on the 8th day of August, entered into a contract with J Business Supplies. Basically, that allows the client to understand that some of the facts are going to be in their favor, some of the facts are against them. I want each one of those facts, as much as we can, what we can prove, what we understand the facts to be then delivered to the client's hands. So that fact pattern sets up what we can use for the rest of the case. And when it gets sent to the client would then have a chance to take a look at the facts, add to them, take away from them, make any changes that need to be made. The second part of that opinion letter is a legal analysis. We want to show the client the facts that they have, how it applies to the law. And we want as much of that law into that opinion letter. That way the client can understand what the law is. Remember, even basic things like negligence that all of us may understand, the client's not going to necessarily understand all those parts. You want to make sure that all the law, the applicable law, is in the client's hands. And then finally, you want to have a conclusion. You want to tell the client this is what our assumption is, and with that conclusion, an idea about what the client can look at as far as total cost in the case. This is basically an opportunity for us to sort of pour a little cold water on the case after we've gone through the process of retaining the client. Sometimes the clients have unrealistic expectations. The opinion letter serves to reduce those expectations, get an idea, open that line of communication, let the client understand that we know what's going on in the case, and have the client fill that in any gaps in the facts or the knowledge that we have, and also have an understanding about what the law and the outcome may look like in a reasonable standpoint. So certainly we want to start with the opinion letter. The next thing is email. Now, emails are going to come in and out of that case. And as those emails come in the case, as I've mentioned on earlier videos, you want to immediately turn them into tasks on the case. Specifically, if the client is emailing you, asking you for an update, whatever that may be, you want to make a task. You don't want to necessarily immediately email them back. You want to set that up so you can organize your day, so you're not beholden to the client's necessary timetable. Use that email to go through. If you have any questions about the case, use all attorneys or all paralegals. Get an idea about what your thoughts are. survey the rest of the attorneys in the firm, see what their thoughts are. Going through that email allows you to generate your billing with the client and allows them to be updated. Now understand that as you build these up and you're doing your time entries, and I recommend after that opinion letter, after the emails, you cut and paste that entire document and put it right into their time entries. Gives them an opportunity to constantly look at what the documents are, what our understanding of the case is, and obviously allows to bolster up those time entries. Remember, the clients are getting those on a weekly basis, therefore the clients know what's going on in their case because of that. The next is briefs. Once you finish that opinion letter, you should immediately be working on a trial brief. That's going to, where the opinion letter is going to basically tell the client these are some of the problems in your case. Obviously, the trial brief is going to be your best argument. So you're putting the facts in that trial brief that help our case, and obviously you're doing your legal work to try to put together in a very concise, specific way what the brief is going to look like. Now, I highly recommend in doing those briefs, use the pattern jury instructions. Remember, the judges are used to looking at pattern jury instructions, and that's the kind of information that the judge wants to know going forward in a case. For family law matters, we've done many briefs. You can use World Docs, search them out. But these briefs are important. Even if you never turn them into the judge, this reminds you what the legal issues are in the case and allows you to answer those legal issues. I recommend going into a discovery at a very early stage. I like discovery out immediately. When there's a case where there's possible issues on the other side, immediately file for deposition. Check the local rules to make sure that you can do that. When you do a deposition, make sure that the other side knows, but you are subpoenaing the actual other party to get them there if that's who you're doing the deposition of. Make sure you define what standard stipulations are. Usually that means that all objections are saved except for the objection of attorney-client privilege and some kind of clarity objection, like that question has multiple, to clarify exactly what the person's answering. On a daily basis in the case, you want to go to ping pong, as John calls it. And basically that means that every time something comes up in your case, send it back to the other side. If there's an email, pop an email back. If you're dealing with your legal assistant, they finished up their task, immediately do the review of that task, then send them another one. If it's opposing counsel, every time that there's a negotiation, you turn around and send it back to them. When it's your client asking a question, you want to turn around and put the homework right back in the client's hands, so they're constantly working on their case. This is not the kind of work where you have to strive for perfection. It is important that we get information back to the client as soon as possible. Being perfect sometimes can take too much time. You want to take enough time to get it done in a quality manner, but get it back in the client's hands. Constantly working and sending things back. You want to give your clients a voice. You don't have to solve all their problems. You want to provide the superior position to the courts. But you want to do that in a manner that allows for that client service to happen. Anytime there's a chance to help the client out, you want to do that. As you get closer to trial, you want to then draft what we call a pretrial order. It may not be technically a pretrial order, depending on what the statute is in that specific area, but you want something that gives you a literal roadmap that you could hand to the judge of all the witnesses in the case, all exhibits that you're going to be using, any legal arguments to expect, and final conclusions that you want to be drawn, or the questions that the court needs to be resolved. That is your final piece of that puzzle. All these pieces, when you start putting it together, allows for you to have a well-informed, fully billed client that's going to be eager to pay their bills because they're excited about the work that's being done. They know what's happening. They know what the trial is. I will make a warning. Don't churn these cases. Don't just do work so you can fill up your billable day. There needs to be value added. All those pieces of puzzles that I just talked about are value added. Don't just have time entries that say reviewed document sent by client. Do something with it. Take those documents and update the opinion letter where you have the exhibits attached. Work on the trial outline. All these are important pieces of the puzzle, which I think allows for us to have good case management. Thanks. Look forward to seeing you in other videos.